All right, hi everyone. Hope everyone is having a great and safe day wherever you are out there in Colorado. We are going to start the webcast. Marsha, feel free to jump on with your camera and your audio. Folks, we are doing it directly from the director webcast. Director Waters has joined us. We are going to start with a presentation. Following the presentation, we will have a Q&A session for you all to ask questions. If you'd like to ask questions in this webcast, the way we will be taking questions is you'll notice there is a chat feature that you have with the GoToWebinar or webcast box that you have there. And feel free to add your question in there. And Pat Hardy, one of our investigators, will be sorting questions when the time comes. So if you bear with me, I'm just going to put the presentation on the screen for Marsha. And once that's on, Marsha, you'll be ready to go whenever you are.
Well, first I'm going to start off. I hope everybody is doing well and that you're staying safe and you're still able to practice within the confines of the public health orders. I did want to kind of give you a little bit of background behind how directly from the director came up. This is actually kind of the creation of two of our investigators. One is Pat Hardy and one is Yvette Gabardi. Pat has gone out and done several speaking engagements to the industry discussing some of the complaint issues that we see with the complaints that we receive from the public. And then Yvette also goes out and does a lot of continuing education course audits, and she hears a lot of feedback from our licensees about kind of how they think we're doing. So based on what they have been experiencing as far as industry interactions, they came up with this series. So we're going to do at least 4 of them. Originally, we had planned on doing them in person, but that's just not feasible. So bear with us. We were joking earlier today that we may be the Division of Real Estate's version of Wayne's World. I'm just not sitting in a basement. I'm in the spare bedroom of my house, which is the room where everybody discards their unwanted objects. So it's kind of like sitting in a storage room. But we plan on going over kind of common compliance issues that we've been seeing. And we also wanted to give you an update on the COVID complaints that we have also been receiving, as well as go through the rules that the commission adopted on June 2nd during their rulemaking hearing. So Corey, do you want to advance the slide? So there hasn't been really any change in the guidance coming out from us or from the Colorado Department of Health and Environment specific to real estate brokers or other real estate practitioners since they have changed it from safer at home to safer at home in the vast outdoors. So you still can't do open houses. A lot of the complaints that we have been receiving have to do with real estate brokers not wearing masks or gloves during showings, and that is a requirement under the current public health orders. So we get about 3 to 4 of those complaints a week. I do have currently 2 active complaints about real estate brokers having open houses. And the one thing that you need to be aware of with the public health orders is there's 3 different scenarios that you could be dealing with. Now, there's the state public health orders, and those are what you have to comply with unless a variance has been issued in a county where they've been able to demonstrate that they've gotten this pandemic under control. And if there's been a variance issued, then you have more lax standards, and you just need to make sure that you're complying with the county public health order requirements. Then you could have a third scenario where you've got a county that actually has more restrictive requirements than the actual state order, and you need to be complying with the restrictive requirements of the county, and also if there's any variance, if the state order is more restrictive, that's what you need to be looking at. So just keep that in mind as you are navigating our current world. If you're going out and doing showings, please make sure you're wearing mask and gloves, and you've got to be doing disinfecting and sanitation of commonly touched areas. I am currently the division's COVID investigator, and it is not a role that I am relishing these days. But the department has taken an approach with the COVID complaints that the way that we're going to handle them is when we get the complaint in, the licensee being complained about, and we call them respondents. The respondent will get notification from me that a complaint has been filed. The respondent gets a summary of what the complaint is about, and the respondent has an opportunity to respond just like any other real estate practice complaint that we would get. The difference, though, is through this process, if the respondent says, I'm really sorry, I didn't mean to do that, I am going to be in full compliance with the public health orders. Once we get that assurance that the respondent's going to comply with the public health orders, then we can dismiss that complaint without any further action taken. Now, if there's a second complaint filed about a respondent violating a public health order, that is probably going to go over into the investigators' world, and they're going to investigate whether you violated the Practice Act. And they can look at it from one of two ways. They can look at it that you are being unworthy and incompetent in your practices so as to put the public at risk, or are you violating one of your brokerage relationships, because your brokerage relationships say that you can't violate any local, state, or federal laws in the performance of your duties, and these public health orders carry the weight and effect of a law. So that is potentially how they could look at it. I will say, fortunately, we've gotten about 15 complaints in at the division about COVID-related violations. And so far, we have not had any repeat offenders, and I hope that it stays that way. I hope everybody just is mindful and does what they can to keep everybody else safe at this time. So that's how we're managing the complaints. Currently, we did have 2 before the department set up its process for dealing with complaints. Those are over in investigations right now. They involve some more blatant behavior because we had a couple brokers that were just blatantly disregarding the public health orders in order to corner a share of the market, and that was kind of the nexus of the complaint. So those are going through investigation right now. And then I have 2 active ones, and those just deal with open houses. So I'm sure we meet weekly to discuss the new complaints that we've received for the real estate broker and the mortgage loan originator program. That happens on Wednesday. So it would be delightful if there were no new COVID complaints tomorrow when we start looking at those complaints, but I'm kind of skeptical that that's going to happen. So Corey, do you want to move on to the next slide? So on June 2nd, the Real Estate Commission considered some revised rules to the ones that we had just gone through and done last year. And really the background for revising these rules stems from us doing financial examinations of the real estate brokerages. So as we've been going out and doing the examinations, one of the questions that the examiners will ask the employing broker is, what other type of brokerage activity do you do? Do you just do sales? Do you do property management? Do you do short-term rentals? And we find that a lot of real estate brokers are doing short-term rentals at this point. Short-term rentals doesn't require a real estate broker's license, but there is a statute that's been on the books for quite a long time, I think longer than I have been at the division, that was raising some concerns within the industry. And I don't think the broader segment of the industry was even aware of this statute. But the statute says that it's a violation of the Practice Act if you fail to account for or remit within a reasonable time any money coming into the licensee's possession that belongs to others, whether acting as real estate brokers or otherwise, and failing to keep records relative to the money, which records shall contain such information as may be prescribed by the rules of the commission relative thereto, and shall be subject to audit by the commission. So what that means is if you're doing short-term rentals and you're taking advanced deposits on those short-term rentals, those funds have to be held in a trust account, and you're subject to all of the accounting regulations created by the Real Estate Commission, and we can audit your short-term rental funds. As this kind of became more and more obvious that this was going to be an issue, we had sat down with several of the real estate attorneys that represent a lot of the real estate brokers across the state, just to discuss the impacts of this, because what a lot of brokers didn't understand was not only did it have to be held in trust, but under the existing regulations of the Real Estate Commission, if I was a broker associate at a brokerage and I was doing short-term rentals, the office policy may say, no, you don't do short-term rentals under the blanket of the brokerage, but because I was taking those funds, my employing broker under the existing regulations was liable for accounting for those funds. So those funds had to go into the employing broker's trust accounts, and the employing broker was having to do three-way reconciliations of my short-term rental advanced deposits. Knowing that a lot of employing brokers probably did not want to assume that additional liability for when brokers were doing practices outside of the scope of their licenses, we started to evaluate the regulations. And so that is why we had rulemaking on July 2nd. Corey, do you want to go ahead and move the slide forward so we can start looking at some of those regulations? Next slide, please. So first, you've got modifications to Rule 1.34, and this is the definition of money belonging to others. So we cleaned up some of the language so that it doesn't say, instead of the broker receiving for the funds, it's the broker accepting those funds. But we also included in that definition rental receipts and security deposits, because those were two types of funds that we were seeing quite a bit of, and that definition really needed to clarify that it applied to those types of funds as well. Next slide, Corey. So then you move into the Chapter 5 rules, and these are the rules regarding how you manage your trust accounts. So as a result of the adopted rules from June 2nd, time is relative these days, June 2nd, which will go into effect on July 30th of this year, we have now parsed out when you're doing licensed brokerage activity and what the requirements are for that as far as trust accounting is concerned, with the unlicensed non-brokerage duties that a broker may be doing. Ultimately, the Office Policy Manual has to distinguish where those funds will be kept. So if the employing broker says, you know, Marcia, if you're doing short-term rentals on the side, I don't want to deal with that, you have to have your own trust account, then the Office Policy Manual has to say that. The employing broker could also say, no, Marcia, I want your short-term rental advance deposits to come through the brokerage accounts. And again, the Office Policy Manual has to say that. Any funds held by the brokerage itself is subject to three-way reconciliation, so that has not changed. What has changed is for the brokers that are going to have trust accounts separate from the brokerage funds, so that's me as a broker associate having short-term rentals, advanced deposits in a trust account that's in my name, what it amounts to is now I'm going to have to do two-way reconciliation. And Corey, can you advance the slide, please? And so here are your examples of some of the deposits that you may be dealing with that would go into the individual broker's trust account. You've got the guest deposits from short-term rentals. If you've got your own investment properties, your security deposits paid by your tenants, those are going to go into trust because that is funds of another. If you're taking deposits because you're acting as a builder, that would go into a trust account as well. Next slide, Corey. And I already kind of went over this. This has to do with your office policy manuals. But basically what you need to know is if you're going to be a broker holding a trust account outside of your brokerage firm, number one, make sure that you check with the bank that you are looking at setting up a trust account with to make sure that they are actually a trust or escrow account, that they've got the fiduciary nature of those accounts. Simply naming an account a trust or escrow account is not sufficient. It doesn't provide the protections. And if you need, we have been working through a list of brokerages, or not brokerages, financial institutions that actually do provide trust accounts. I know that First Bank is one of them. I think Bank of the West may be another one, but I would have to double check on that one. But you can definitely submit an inquiry and we can get the list out to you, or we'll look at just posting that list on the website itself. The funds have to be immediately available without penalty. Now, with conversion or diversion, what you have to be careful of is if you're dealing with your own investment properties, so you've got the tenant security deposits, those have to go into a trust account. But as I'm collecting rental proceeds on my own investment properties, those cannot go into a trust account because those are not funds of another. Those are my funds. So you've got to make sure that you keep them separate. Otherwise, if you put them in your trust account, that is commingling. Conversion or diversion is when you're using funds that belong to one person and you're using them for the benefit of another, and that's a license law violation. You need to maintain a journal. And then the two-way reconciliation is basically you're going to be reconciling your journal entries with your actual bank balance to make sure that they match up. So those are the new accounting standards that will go into effect July 30th. And I know some of the questions that have come up is, well, if I'm a broker associate and I have a trust account of my own for my own investment properties, or it's short-term rentals, whatever the case may be, is there specific naming requirements? We have not put naming requirements on them. You just have to make sure that they are a trust or an escrow account. So if you want to call it Marsha's Vacation Properties, you can do that. Just make sure it's a trust or an escrow account. Next slide, Corey. And then we can go, I already covered that one, so we can go to the next slide. I go faster than the slides, so could you go to the next one? And the next one. The last one that the commission adopted, and it's probably the next slide, Corey, has to do with a modification in one of the rules for Chapter 6. And this was a new rule that came about on January 1st that deals with listing contracts have to be in writing. We just cleaned up some of the language. So basically the rule now says that all seller listing contracts and landlord listing contracts must be in writing prior to performing any real estate brokerage services. One of the reasons that we asked the commission to adopt this is it wasn't happening very frequently, but over the years you would have a broker that would say, oh no, I had a listing agreement to sell that property for the seller, but I was a transaction broker, so there was nothing memorialized in writing, which I'm not really sure how you memorialize the terms of a sale with your principal when you don't have a written agreement. So that was one of the reasons that the commission adopted that rule, and we just cleaned up language at the June rulemaking hearing. So these modifications will also go into effect on July 30th of 2020. Okay, next slide. So another area that we hear a lot of concerns about has to do with affiliated business arrangements. And so if you have ever looked at the statute regarding affiliated business arrangements, it is not the most easy statute to have to navigate, but let me read you the definition of what an affiliated business arrangement is, and you will probably hear me refer to it as the acronym of an AFBA. So an affiliated business arrangement means an agreement in which, one, a provider of settlement services or an associate of a provider of settlement services has either an affiliate relationship with or a direct beneficial ownership interest of more than 1% in another provider of settlement services, and part two, a provider of settlement services or the associate of a provider directly or indirectly refers settlement service business to another provider of settlement services or affirmatively influences the selection of another provider of settlement services. So, and it goes on to also define an associate, which means a person that has one or more of the following relationships with a person in a position to refer settlement service business. So number one is a spouse, parent, or child of the person. Two is a corporation or business entity that is controlled by, or is under common control with the person. The third category is an employer, officer, director, partner, franchisor, or franchisee of the person, including a broker acting as an independent contractor. Or lastly, anyone who has an agreement, arrangement, or understanding with the person, the purpose or substantial effect of which is to enable the person in a position to refer settlement service business to benefit financially from referrals of the business. So not the easiest statute to even start to navigate, and it goes on for a couple more pages. But what you need to be aware of as far as affiliated business arrangements are concerned is that, number one, they're not bad. You just have to actually refer, you've got to, if you're going to refer somebody to an affiliated business arrangement, you need to be making certain disclosures, and there's 3 different categories of disclosures that you have to make, and ultimately it's the consumer's choice. You can't force somebody to use an affiliated business arrangement of yours. So the first category of disclosure is you're going to have to disclose your affiliated business arrangements with the real estate commission. So if you're the employing broker, you are making that disclosure on an annual basis, and you're doing it on behalf of the brokerage. All other brokers, you're going to be making those disclosures anytime that you are acquiring an affiliated business arrangement, you're losing an affiliated business arrangement, or you're going from inactive to active status, and you're going to have an affiliated business arrangement. So that is the first disclosure that you make. And we've got a Google document on our website in order for you to make that disclosure. It's relatively painless. Then you've got when you start referring people. So if you've got a client that's, for example, I'm a real estate broker, I'm going to refer my client over to my husband's mortgage company. So at or before the time of referral, I need to be making that disclosure to my client, and ultimately they get to decide whether they want to use that mortgage company or not. And then the Real Estate Commission does not have a specific disclosure form for you to use. Ever since this law was passed back in, I think it was 2006, the Real Estate Commission basically decided that they were not going to promulgate their own form because of the connection to RESPA. So pretty much the Real Estate Commission said, use the HUD form and that will comply. That's the second type of disclosure that you have to make. Then there's the last type of disclosure. So say like my buyer has decided that they want to use my husband's mortgage company for their loan. We find a house, we submit a contract. At the time of contracting, we need to also be disclosing to the other side of the transaction and their brokers that there's this affiliated business relationship that exists between my real estate company and the affiliation. Basically, my husband is an associate of an affiliate at this point. We've got to disclose that as well. So just make sure that you're using the HUD form and that you are keeping those in your files, because we do see it from time to time where the disclosure is not made. I have heard a lot of brokerages say when I go out and speak at their offices that your clients are using my title company. I would not encourage that message. That's probably going to trigger a complaint with us and also kind of catapult you into the world of the Consumer Financial Protection Bureau, who now regulates RESPA, because that sounds like a RESPA violation as far as we're concerned. So just make sure you are doing the 3 different types of affiliated business arrangement disclosures, and you should be okay as long as you're also allowing them consumer's choice to pick. Ultimately, they can say, no, I don't want to use your husband's mortgage company, Marcia, and then they can go on their merry way and find their own lender. So the last category of compliance-related issues that we have seen, and this was actually suggested that we do something maybe in the newsletter about this as well, has to do with real estate brokers, our licensees that post-licensure have a run-in with the criminal justice system. And I will tell you that it happens quite a bit. I can't give you really kind of a stat right now about how many cases that we have that involve real estate brokers with prior criminal convictions that have occurred post-licensure. I do think we assigned about 4 new complaints last week. What happens these days is you have all been through fingerprinting at time of application or renewal. So if you go out and get arrested, we will get a flag from the Colorado Bureau of Investigation that says, hey, Marcia robbed a bank this afternoon, and so you need to start tracking Marcia's bank robbery case. And I do have somebody down at the division that does track those cases to see where they're at along in the process. And then once we find out that there has been a guilty plea, a conviction, or a plea of no contest, typically we find out within just kind of a couple weeks of it occurring. It will then get assigned to an investigator for investigation. The important thing that you all need to be aware of is, number one, there's a whole laundry list of criminal violations that if you plead guilty to, are found guilty of, or plead no contest to, those constitute a license law violation in and of themselves. So the Real Estate Commission can discipline you. And then there is a second requirement under the Practice Act that within 30 days, you have to be notifying the Real Estate Commission that you've had either one of those criminal convictions or one of those pleas. And not all of them are created equally. It's not just felonies that you have to report to the Real Estate Commission. There's a bunch of misdemeanors contained in that list as well. And the Real Estate Commission typically is going to evaluate how long ago did this occur, how egregious was it, did it involve real estate practice, and they will use kind of those different factors to decide how they're going to address the criminal violation with that broker. And to give you kind of some ideas of what we've seen over the years. So anytime a broker has been involved in forging documents and filing forged documents, that's usually not a that's not going to end pleasantly. They're probably not going to be able to keep their real estate broker's license. The commission has pretty consistently revoked licenses for that. We have seen brokers that have gotten into, they've had third-degree assault convictions. When we do an investigation, we might find out, okay, there was a bar fight or something. Typically, that type of scenario where it's not real estate related, the real estate commission will issue a fine, and that will be about the extent of it. We have seen some non-real estate related ones, though, where the real estate commission has said, no, we don't want you to practice anymore. So we did have one real estate broker hire an undercover police officer to kill his wife. Fortunately for her, he hired an undercover police officer to try to kill her. So she is still among the living. The real estate commission heard the facts of that case and decided that he was just such a threat to the general public that they did not want to license him anymore. He did try to give the plea to the real estate commission that, you know, this was not real estate related and he's not a threat to anybody's safety. But they didn't quite buy that because he's the threat to at least her safety. So he is not among the licensed population anymore. We've had a couple brokers that have committed mail fraud over the years. And some of them have been elaborate schemes where they have actually left the country and then come back. We've got one that will be paying restitution for 1,300 years. I don't quite remember why they allowed her to keep her license. We were kind of stunned at the staff level, but she was one that they did allow to continue to practice. Part of the reasoning behind that was because she had some glowing letters of recommendation from some pillars of the real estate community. And then we have seen a few brokers, and this is real estate related, where they've burglarized their own listings. We had one in the Boulder County area that was burglarizing his own listings, and he was stealing drugs from cancer patients. Fortunately, we found out because it made the news media before his case actually came to conclusion with the criminal justice program, and we were able to kind of reach out to the courts, and the courts actually ordered him to give up his real estate license along with the action that the real estate commission took. We had a broker up in the mountains burglarize one of his listings, and he stole a very unique leather jacket out of the property, which he then wore to go get fingerprinted for his real estate broker license renewal. And fortunately, the officer in that area recognized the stolen property, and he got basically fingerprinted for not only his broker's license, but also the burglary charge. So just bear in mind, if you do have a run-in with the criminal justice system, not everything is going to result in the revocation of your license, but you need to be making sure that you are immediately notifying the real estate commission that you have had that misstep, because that can be an additional violation, which means that if it's something where you kind of had that bar fight scenario, it's going to increase the amount of fine that you're going to have to pay to the real estate commission. And so those are pretty much the compliance issues that we were going to address in this webinar. We wanted to give everybody ample time to be able to submit questions via chat, just basically due to the new rule changes that will be coming down on July 30th when they go into effect, and also any kind of looming questions that you guys currently have. So with that, Pat Hardy will be, there she is, and she is going to be kind of the moderator for the questions.
Thank you guys for submitting so many good questions. We have a ton of questions, and we'll get to absolutely as many of them as we can. Let me say first, there have been a couple of people who have been having trouble seeing the slides, and so the whole presentation today is being recorded, and it will be emailed out to everybody so you can follow up. You'll be able to see the slides in that recording, and then you can also pass that link on to anybody who wanted to be here but was unable to do so today. So we have a bunch of questions. One of the first ones, Marcia, was, do you know of any upcoming changes that will allow open houses again?
So I haven't heard of anything yet. And I know that that has been something that the industry is kind of chomping at the bit to start doing. But we just have not, once it transitioned from safer at home to safer at home with the vast outdoors, there was some heads up that some things might be changing for the different DORA divisions, but I haven't heard anything specific to open houses. So at this time, you still can't do them unless you want to do a virtual open house.
Do you have any thoughts on why it seems like builders are still able to do them or are still doing them?
well, unfortunately, so I don't know that builders technically can still do them. You just don't have the outlet for builders like you do for us, where you've got the regulatory agency. I don't know what would happen if you turned a builder into the local health department, though, because some of the health departments have been a little more aggressive on dealing with the violations that they hear about. So that is one potential avenue. I know it has created some animosity with the real estate brokers because it really appears that there is an unfair playing field at this point. You guys can't do open houses, but the builders can. So I would encourage, if you're seeing open houses in areas where they don't have a variance that would allow an open house, I would contact your local health department.
And when you're referencing open houses, does that mean the same thing for if it's a broker open house as opposed to an open house available to the public?
I think it includes both.
And someone was wondering if the complaints are anonymous.
Some are anonymous, some are not. I would remind you that technology can be a godsend these days for some people. And I know last week when we got, I think, 3 new complaints, one of them involved like Ring doorbell videos. And I was able to watch the broker walk in and out with the clients, and they didn't appear to be wearing masks or gloves. So bear in mind that technology is out there, and a lot of people, this is very stressful to them. The concept of having potentially, another complaint that we've been getting is just the sheer multitude of people going into the property. One of the complaints last week was like, the broker let 8 people go into the property. You've got that limitation of 10 at the state level, but really you should be looking at only those people that are going to be signing the contract should probably be going into a property at this time, just to further limit the spread of COVID.
And do you have any guidance that you can offer in terms of who should be disinfecting the houses between showings?
It's going to fall pretty much, I think, on both brokers at this point. That was kind of the guidance that we put out there, is that, I mean, it's going to be challenging. If I'm taking a buyer through a property, how is the listing broker going to know what the buyer has touched? And one of the things I would be doing if I had a listing is trying to prep that property as best as I could so that there was minimal touching going on. Keep your closet doors open. Anything that people are inclined to want to examine, if you can keep it open so that they're not having to touch surfaces, that's what I would be looking at doing. But really, I think the onus falls on both the seller's broker and also the buyer's broker.
Okay, and we have a lot of questions about the new accounting regulations. So one of them is, if I have 10 rental properties, do I need 10 separate trust accounts, or can all of the security deposits be put into one trust account?
You can put them all in one trust account.
Okay. And if I'm collecting first and last month's rent, does the last month's rent go into the trust account or the operating account?
So I think that one's a little tricky. First, I mean, the first month's rent, obviously, that's going to be rental proceeds. Basically, you're dealing with rental proceeds, so those would not go into a trust account.
Okay, and there seems to be quite a few questions about how the account should be labeled. So if trust is in the label, is that sufficient, or are there different characteristics that make it a trust account?
There's different characteristics that actually make it a trust account. So just having it in the label is not sufficient. You need to make sure that it's actually an account that, and an example of why we wanted it in a trust account is we had a complaint a couple years ago where the broker was maintaining trust accounts. The broker, for whatever reason, filed bankruptcy. When you file bankruptcy, they shut down your accounts. That doesn't happen if you have an actual bona fide trust account that you're holding funds of others in. Unfortunately, with that broker, I don't think he did, and I think it was just a trust by label only, and that becomes an issue because the bankruptcy court went to sweep the funds, and those did not belong to the broker. So there are protections in place with a trust account beyond just the name of a trust account.
And someone asked, why is the security deposit considered funds of others? Isn't it my money until and unless I have to return it to the tenant?
Those are the tenant's funds. And so if everything goes as it's planned and there's no damage to the property, they've paid rent on time, you have nothing outstanding, at the end of that term of lease, you're going to be releasing that security deposit back to the tenant. So that is never your money. That is the tenant's money. And I would also encourage you, for those that do rentals, when you start looking at keeping security deposits or not returning them in a timely manner, the civil ramifications of doing that are pretty aggressive. I would consult with an attorney on that. That's kind of outside of our bailiwick, but the security deposit itself, those are tenants' funds.
Okay, and so I think you kind of answered this, but I have tenant deposits in a separate savings account. Is that sufficient?
No, it needs to be a trust account.
How about if I own rental?
Checking accounts.
If I own rental properties, but my license is inactive, do these rules still apply to me?
So you still have to keep money of others in a trust account, even if your license is on an inactive status.
And what if the properties I own are in a different state?
So I will follow up with that one after this webinar.
Okay, another person asked, if I need to add some of my own funds in order to reach a minimum balance to reduce the fees on the account, is that allowed?
So you are allowed to put broker funds in there to keep the account balances from going negative. One of the things that we're going to look at, though, when we come out and do an audit is, does it appear that the amount that you are placing in there for broker funds, is that a reasonable amount? Because it shouldn't be like a slush fund. If you only manage like 2 properties and you want to make sure that you're not somehow going in the negative because every month you have $100 worth of bank fees, then we would not expect to see you putting like $2,000 worth of broker funds in every month to cover $100 worth of bank fees. So that is something that the financial examiners will look at. They'll look at the book of business, kind of what your standard bank fees are, and that's how we kind of gauge reasonableness as far as how much of the broker's funds are placed in the account.
And how do the rules change if the ownership interest is less than 20%?
So if it's less than 20%, you don't fall kind of under that. It's going to have to go into the brokerage trust account because the 20% is the threshold where you can do it on the side, essentially. You've got ownership.
So if my managing broker does not want to be involved in my rental trust account, is that okay?
It is, as long as your rental trust account, you own the property more than 20%, and the employing broker needs to write that into their office policy manual.
What if I received the security deposit prior to July 30th? Do I still need to abide by these rules?
Yeah, you're going to need to make sure that it goes into a trust account.
Okay. We've got a couple of questions about disclosing, for example, does the division require disclosure of a DUI?
Fortunately for the real estate industry, we do not. I think we would have less than a handful of actual licensees if DUI prohibited you guys from having real estate licenses. I say that jokingly, but when we went through fingerprinting at time of renewal in 2005, 2006, and 2007, there were a lot of people that had DUIs. And even with new applicants coming in, if they have a DUI, that's not something that the Real Estate Commission considers. What we do look at, both pre-licensure and post-licensure, are DUI-related offenses concerning vehicular homicide and vehicular assault. Those are both felonies, so the Real Estate Commission would consider those in making a licensing determination, whether to grant somebody a license, and then on the back end, it's something that they could discipline your license for if you had one of those convictions.
And how about traffic violations?
Typically, traffic violations are not going to fall within the scope of what the Real Estate Commission is going to look at, with the exception being if you achieve that lovely status of being a habitual traffic offender, which is typically a felony, then that is something that they may consider.
And someone has asked, my attorney said a deferred sentence means I don't need to report because I am only, in quotes, convicted if I don't complete the terms of my deferment. Is that accurate?
So deferred sentences work a little differently depending on how we are dealing with them. So if you're an applicant coming in and you had a deferred sentence, if it's active, we're going to look at it. If you've completed the terms and the deferred has been closed, unless there are some real estate related underlying factors, typically we don't even acknowledge the presence of those. Now, if there are some real estate related underlying factors, what we can do is investigate the underlying factors, and those may speak to your truthfulness, honesty, and good moral character to be granted a license. Post-licensure, a couple years ago when we went through the sunset review process, the Attorney General's office actually recommended some changes in the language regarding deferred sentences. And previously, before that language changed, it was the entrance of a plea, which you do enter a plea when you're looking at a deferred sentence. The plea is then just kind of rescinded once you complete that deferred sentence. They added some language specific to deferred sentences. So if you have an active deferred sentence post-licensure, the Real Estate Commission can look at that, and they can consider disciplining your license for it. The other thing that we're dealing with currently is a decision that came out of the Office of Administrative Courts, though, where an administrative law judge said that once the deferred sentence has run post-licensure, that the licensing authority can't consider it. So what you will tend to see when we have deferred sentences post-licensure that we're dealing with, the clock is either ticking, so we're trying to get the investigation done quickly so that it goes in front of the Real Estate Commission before the deferred sentence runs, or given the circumstances, what we can do is look at the underlying behavior, and the underlying behavior can speak to another license law violation, such as dishonest dealing or unworthiness and incompetence.
Okay. I'm going to jump real quickly to a couple of affiliated business disclosure questions. If I own a construction company, does that need to be disclosed as an affiliated business, or is it only settlement services providers?
It's settlement service providers. So if they're involved in the settlement of the transaction, that's what you have to disclose. And I'm looking at the list. So I'll read off the list of what is considered a settlement service. However, I think construction, I would be erring on the side of caution, because you're dealing with a builder, and that's part of building the property could be considered part of a settlement service. So I would be consulting with a RESPA attorney on that one. The list within the statute says any service provided in connection with a real estate settlement, including but not limited to, so that's why I think construction would be looped into this, the following: 1, title searches; 2, title examinations; 3, the provision of title certificates; 4, title insurance; 5, services rendered by an attorney; 6, the preparation of title documents; 7, property surveys; 8, the rendering of credit reports or appraisals; 9, real estate appraisal services; 10, home inspection services; 11, services rendered by a real estate broker; 12, pest and fungus inspections; 13, the origination of a loan; 14, the taking of a loan application; 15, the processing of a loan; 16, underwriting and funding of a loan; 17, escrow handling services; 18, the handling of the processing; and 19, closing of settlement. So I do think construction would fall into one of those categories. I think it would just be under that really vague, broad gamut of not limited, including but not limited to.
And is it an acceptable practice to use your the affiliated business in your advertising?
Well, what you need to be careful of is, if you're going to use affiliated business in your advertising, you need to make sure that your costs are not offsetting their costs. So if I was going to team up and I was going to take out a full page ad in the Denver Post, which I don't think anybody does anymore, and half of it was going to be my real estate company and half of it was going to be my husband's mortgage company, I can't pay for it at his benefit. He would have to pay 50% for him and I would have to pay 50% for me. That's how we've viewed it. The caution that I would have, though, is I don't know how the CFPB would view it. And marketing agreements in general under the CFPB, with some of the actions that they've taken, I don't think if I was to go out and start practicing real estate brokerage tomorrow, I don't think I would want to go down the road of having a marketing service agreement, because I think there are too many unknowns and the CFPB is really aggressive on enforcement.
Good to know. Just as a point of clarification, did you say that there's an affiliated business disclosure form on the HUD website?
The HUD did create one, and the last time I looked, it's been a while, it was still up there.
Okay. So just for clarification, if I'm a broker associate and I own some rental properties, under my name, do I need to transfer the security deposits into my broker's escrow account or into a special trust account, even if I had those deposits before starting employment with my broker?
So first off, it's going to depend on what the broker requires at this point. If the manager or the employing broker is saying you have to place those security deposits with the brokerage, then they're going to have to do that. And even though this is like post-adoption of the rules, come July 30th, you've got to be in compliance with the existing rules. So if the employing broker does not want those security deposits held in the brokerage trust accounts, hopefully the office policy says that, and then the individual broker is going to have to establish a trust account that is an actual trust account to hold those security deposits.
And if I own 3 or less properties and operate only my 3 properties and I'm the 100% owner, am I exempt from those laws?
There isn't an exemption. So those 3 properties, if you've got 3 investment properties or 2 of them are investment properties, the security deposits for those still have to go into a trust account.
And if I need to move security deposits that I currently have held in a bank account labeled escrow, but without protections, are there requirements for notifying my tenant that the funds are being transferred?
No. The only time you have to do the notification to your tenant is when you're going to have owner-held security deposits, and that's when you need to be notifying the tenant, letting them know that the owner is holding those. But if you're changing bank accounts, you don't have to notify the tenants.
Okay. Let's see. Oh, and can you clarify, in terms of short-term rentals, are you saying Airbnb?
That could include it.
Okay.
Even as a real estate broker, if I decided to open up a painting company tomorrow and I was collecting deposits for my painting company, because I have a real estate broker's license and because we have that statute on the books, those painting deposits would have to go into a trust account and I would have to do the reconciliation requirements established by the commission.
Okay. If I own properties in multiple LLCs, can the security deposits be held in one umbrella trust account for all of the associated property LLCs?
I think we're going to have to put our heads together on that one after this webinar.
And just to mention it, there is something on the screen right now where you can see that you can forward questions in the future to Dora_real estate_website at state.co.us. That'll be available for you also when the link is sent out of this recording. Again, is there a limit to the number of rental security deposits that can be lumped together in one trust account?
No, I mean, we've seen brokers where they've had trust accounts for every single property, and that to me sounds nightmarish. but no, we don't have a limit.
And regarding rent collection, does the rent need to go into a separate trust account other than the one holding the deposits, or can it go directly into a personal bank account?
Well, if it's your rental proceeds, you can put it in your bank account. If it's rental proceeds for the landlord that you're managing the property for, that needs to go into a separate trust account, separate from the security deposits.
Okay, let's see if we, some of these are a little bit duplicate, so I'm sorry for the delay, but I'm just looking through to see, make sure we got everybody. Let's see. This is where you have to like stretch.
Well, so I did say that we were going to do probably a total of at least 4 of these. And I know that we'd sent out a survey a few months ago in preparation for this, but if anybody has any topics that you would recommend us covering, you can definitely submit those suggestions as well. We welcome them.
How do you comply with trust accounts on July 30th if you have 30 existing deposits that have been deposited into my personal account, but now I have to get all of that money into a trust account by the deadline?
Well, so you have over a month to move them into a trust account.
Okay, and then we've got a commercial.
Technically, the requirement exists now. I mean, those funds technically should be held with the employing broker in their trust accounts, and we'd be subject to 3-way reconciliation. So I would jump on compliance right away, but as far as moving them over into a trust account in your name, separate from your employing broker, that regulation goes into effect on July 30th.
Okay, we've got a question about commercial leases. In commercial leases, there's often verbiage around the landlord being able to do anything with the deposit because it's tied up for 5 to 10 years often. Can we use these funds if the lease says we can on commercial, for example, real estate, industrial, or office properties?
I guess my question would be is how would they be being used? I mean, if there's something in the lease agreement that allows the landlord to use them, they wouldn't be able to be used for the broker's benefit. And that's something that the tenant would be agreeing to for the landlord to be using. So that tells me also that the broker wouldn't be holding those funds, they would be held by the landlord. We might need more information though.
Yeah, we'll see if that person posts a follow-up. Does the commission have any authority over home builders providing incentives to buyers?
Unfortunately, we don't have jurisdiction over the home builders. And I don't know that attempts to regulate home builders would be very successful. They usually have a pretty powerful lobby, but that is yet another area where there seems to be some disparity as far as the playing fields of practice.
Okay, it looks like they were referencing specifically incentives to buyers using the builder's own mortgage company.
And I'm not exactly sure how the builders have been able to get away with that under RESPA, but I would definitely encourage you to reach out to the CFPB.
Okay.
Since they regulate RESPA.
Let's see, it looks like we're getting a lot of duplicates now. So I'm an independent broker and am my only employee. I also have a separate business where I manage my own rental properties. The businesses are totally separate, including bank accounts, LLC ownership, etc. Does the 3-way reconciliation requirement for property managers apply to me?
So I'm going to have to go back and look at the new rules to see how they've kind of parsed out employing brokers versus independent brokers. I will admit, I do not have our new rules completely committed to memory. After the recodification of the statutes last year and then the rule review project that happened, I feel like I have encountered amnesia, and so I now get to regularly go back and read the new rules to see what they actually say.
All right, on a different then. I am nearing retirement, have one rental property, it's not a short-term rental, but a long-term rental. Must I open a separate account just for my rental deposit? Any way to avoid this since it's just for one property?
Well, if you're a one-person shop and you don't have any trust accounts, then you're going to have to set up a trust account for that one property. If you work for a broker, that might be a good time to have a discussion with the broker to see if that security deposit can be held with your employing broker's funds. But when you retire, you're still going to have a trust account requirement if you maintain your license. If you let your license go, you're no longer subject to the jurisdiction of the Real Estate Commission.
Okay, and I think I've answered that. Is there a minimum number of properties that requires these accounting rules?
Even if you have one, you're going to have a trust account.
Let's see. For brokers who engage in rental properties as individuals outside of their brokerage business, so they just rent them personally. Yeah, I think it would seem that the accounting rules and trust accounts do not fall within the CREC rules. So to be clear, the rules for accounting only pertains to that business conducted in the name of the brokerage. Is that correct?
No, that is not correct. So if you, okay, here's an example. So say like I work for a brokerage that only does sales, and then I've got, I don't know, 5 of my own investment properties on the side. I'm going to have a trust account set up to deal with the security deposits for those 5 investment properties that I own, even though it has nothing to do with the brokerage that I am licensed with.
And can you cover any brokerage disclosures that brokers should be using for their own rentals?
Well, I mean, obviously, one of the things that you need to make sure that is abundantly clear is that you are disclosing to them that you have a licensed Colorado real estate broker or Colorado real estate broker's license, because that's going to be the conflict of interest. Additionally, you've got to do your brokerage relationship disclosures, and they need to be aware that you can't be their single agent because you're the landlord. I think those are the primary ones.
And if I have a property manager overseeing my rentals and they are not in compliance with the trust accounting, am I liable?
No, you wouldn't be liable. Well, no, because you've hired somebody else to do the business for you. But I would be probably filing a complaint with us because they're not in compliance.
Okay. I know that we had outlined an hour for this and we're kind of closing in on that. Just going to check and see if we've got any others going on. I think that looks like about it.
Well, thanks everybody. Stay safe.
All right, well, thanks everyone. Like as it was said earlier by Marcia or Pat, we will be sending out a recording of this for everyone who's attending today, and we'll be providing you, as you can see on the screen right now, an opportunity to ask additional questions. Follow up from this webcast will also be in the quarterly newsletter coming out in July in the Director's Corner, so you'll be able to get more information at that point as well. And thank you for participating. We appreciate it, and I'm going to shut down the webcast as of now. Thanks, everyone.
Thanks.
Thank you.